welcome to FFRF's Ask an Atheist. I'm Sam Grover, Senior Litigation Counsel here at the Freedom from Religion Foundation. This week, we're taking a look at a case to be decided by the U.S. Supreme Court that will determine if religiously affiliated nonprofits should be exempt from paying into an unemployment insurance system, even when their work is entirely secular. So the case involves a Wisconsin-based Catholic organization, Catholic-affiliated organization, but the court's decision will affect the entire country, and we'll explain how. Joining me is our guest labor and employment attorney, Victor Forberger, along with FFRF staff attorney, Sammy Lawrence, and legal fellow, Hirsch Joshi. Victor, hello, welcome to our studio.
Hi.
Victor, do you want to explain who you are and the work you do?
Well, I'm a labor and employment attorney. I've been here in Wisconsin now for more than a decade. Got involved in unemployment cases back when the Great Recession was happening, and kind of because of a lack of other attorneys now, it's become, I've become one of the major attorneys involved in the issue. And so I started following this Catholic Charities case back when it was at the appeals court here in the state. Then I went to the state Supreme Court, and now it's at the U.S. Supreme Court.
That's right. And Sammy?
Yeah, people will probably recognize me. I've been here at FFRF for a while now, and I helped author FFRF's amicus brief in this case. And so did Hirsch Joshi, who is joining us remotely today.
Hi, Sam. Hi, Sammy. Hi, Victor. It was a privilege to work with you guys on that brief.
So, perfect. As always, in addition to hearing from Victor, Sammy, and Hirsch, we want to hear your thoughts on the topics we discussed today. So please leave your questions in the chat below or email them to askanatheist@ffrf.org. We'll try our best to answer your questions live during the show. Now, Sammy, why don't you start us off by giving the audience a brief summary of the case and how it got to the Supreme Court?
Sure. So essentially, like we alluded to, this case is about a Catholic-affiliated organization here in Wisconsin trying to get out of being part of the state's unemployment program. Right now, under Wisconsin law, there are some exemptions for religious employers, and that one of the requirements is that if a religious employer is operated primarily for a religious purpose, then it can be exempt from the unemployment system. Catholic Charities Bureau and 4 of its subsidiaries argued that they should be exempt, but our courts here in Wisconsin said, hey, you are not actually operated for primarily religious purposes because your work is secular. They're doing completely secular charity work that is not actually religious activity. Of course, Catholic Charities did not like that, so they appealed the Wisconsin Supreme Court's decision to the United States Supreme Court, where they just held oral arguments yesterday, actually. And like we mentioned, FFRF filed our own amicus brief in this case, but so did Victor. So to get us started on some conversation, Victor, do you want to tell us a little bit about what your amicus brief argued?
Well, I had a very minor role in that. I was more an organizer than writer. Brenda Lewison and Larry Dupree and several others were involved in doing the mantle of that writing. And essentially was kind of spotlight, what is the impact of unemployment benefits and how widespread they are, and what this kind of change might mean. And one of the issues that came up in the oral argument is, what about Catholic hospitals and religious connected hospitals? Do their employees get excluded? And the argument made by the petitioners in the oral argument was, yes, they will probably be excluded if their argument is accepted as it's being presented, which would mean 1 million plus employees at hospitals would suddenly be exempted from unemployment benefits. And we also talked about in that brief kind of the history of unemployment benefits, that Wisconsin actually invented or started the unemployment benefit process, and originally was created as a voluntary process. The idea is that employers necessarily didn't have to participate. We didn't want the government to mandate their participation. As typically happens with voluntary programs, it didn't quite work out. And they couldn't get enough employers to actually voluntarily provide unemployment benefits to their employees. And so when the unemployment system got incorporated in the Social Security law that got passed in the late 30s, that's when unemployment became mandatory, even in Wisconsin and all the states.
Yeah. And so then that's the unemployment insurance scheme for the state. Let's talk about that narrow exemption in it. My understanding is basically the idea is we're going to let churches who have, their religious figurehead be exempt from paying into that system with the understanding that, they have other ways of compensating their religious figureheads.
Yeah, it's actually broader than that. Any kind of employees, so the priests, the rabbis, the nuns, the pastors, the janitors, sextants, I think they're called in churches, they're all excluded from unemployment benefits because they're all part of the church or the synagogue or whatever that church body is. And so religious schools, the teachers in religious schools are also excluded from unemployment benefits. What is different about this case, though, was churches are allowed to have all kinds of activities. And so under the law, they're saying, well, what about the other activities that aren't connected to the church? Are those also going to be excluded? And so a two-part test was created. It's not just that there has to be a religious motivation to it, and also the activities have to have a religious focus or religious base. Hence, like the schools, if you're teaching a religious class, that's going to end up meaning that school is going to be excluded. In this case, the activities aren't religious at all. These are, in this situation, it's northwest Wisconsin. They're providing, for the most part, support services and training for disabled clientele. And it's all funded through basically federal and state dollars. I think there's 5 entities and one gets some private foundation money as well. Mm-hmm. But it's all government dollars essentially. There's no church money actually involved in this case.
Right, and those same activities could just as easily be performed by a non-religious entity, right?
And
someone completely unaffiliated.
Yeah, and they generally are being done by non-affiliated charitable organizations. But because in northwest Wisconsin, it's not a very populous area of the state, and so in that area, the church is one of the main organizational administrative bodies, which is also why these nonprofits, they originally were, for the most part, were independent of the church, but over time they affiliated with Catholic Charities for administrative overhead. So essentially, instead of having their own administrative staff and processes, they turned to Catholic Charities to create that administrative overhead to manage the grants that they were receiving from the state and federal agencies.
Yeah. All right. So before we turn to how the Supreme Court treated that very complicated and nuanced situation, let's talk a little bit about our amicus brief. I want to bring Hirsch into the discussion. So Hirsch, what did FFRF's amicus argue, and why did we pick those arguments?
Sure. So we had a few different arguments. So one that I particularly liked and that got a little bit of lip service during the oral arguments was the sweep of the rule that Catholic Charities was asking about. If you could never, of course, look at the activities of a religious organization, how far does that take us in federal public policy and even towards the states? We also started to argue something about, Catholic-owned hospitals, and I think Sammy did that section of statistics and how many employees would be affected almost immediately should the petitioners win. And I think, Sam, you might have done the very first section, so I'm going to let you talk about that.
Well, why don't we? I think we've got a clip here that has you discussing one of our arguments. So let's play that.
If your coffee shop advertised itself as a coffee shop, was maybe owned by a coffee business, but never sold coffee, would they still be a coffee shop in your mind? And if the answer is no, not at all, Hirsch, well then you can kind of see why the Catholic Charities of Superior, Wisconsin was denied this exemption, right? Yes, they're affiliated with a local diocese. Sure, they call themselves Catholic, but they don't really do anything religious, right? What they provide is services to individuals with developmental and mental disabilities, pretty much a secular service. And fast forwarding just a little bit to the Wisconsin Supreme Court, 4-3, that's kind of what they held, right? That what Catholic Charities does is secular in nature. It's not really religious, therefore they're not primarily operated for a religious purpose, exemption denied.
Yeah, I think that's a very concise hypothetical to sort of summarize how the Wisconsin Supreme Court landed where it did, right? Catholic Charities' response, one of their responses at the Wisconsin Supreme Court oral argument to this line of argument, not that the coffee shop hypo came up, was basically to say, yeah, okay, the actual services we're providing could also be provided by a secular organization. But our reason for providing these services is religious, right? Our interest in helping the poor is a religiously motivated reason for doing this work. And that should be enough to get this religious exemption. And I think that's why we are then raising this red flag about, well, religiously affiliated hospitals, right? Because it's very clear that Catholic affiliated hospitals in this country, which amount to somewhere between 20 and 25% of all hospital beds in the country, they're doing that work for religious reasons. Their motivation is religious, even though the work they're performing is, medicine, secular medicine.
Yeah, exactly. And like Victor mentioned, and a lot of the amicus briefs mentioned, this has like really clear practical implications for real human beings working jobs at any kind of employer that happens to be Catholic affiliated or even religious affiliated. Obviously, this ruling would not be limited to Catholic organizations, but unfortunately, at oral arguments, the Supreme Court yesterday really chose to focus on very abstract hypotheticals that were in a lot of ways completely removed from the real situation in front of us. For example, one of the hypotheticals that came up early on was about a vegetarian restaurant and somehow comparing a vegetarian restaurant to religion and a church. And I think we have a clip of that for the audience just so that they can see what we're talking about.
What if you have a religion that thinks it's a sin to eat meat, and they, to promote the eating of non-meat dinners, they open a restaurant, but it's only vegetables and non-meat. Do they have a claim to be exempt from state taxes? Food taxes, everything else, because that's it's a sincerely held belief and it's important to them, and you're going to be taxing them. You're going to be taxing the exercise of their beliefs.
So I think it depends on whether the statute that's imposing the tax says this applies to meat-eating people or not to meat-eating people. That's
well, it
just
what we applies. It applies across the board, and they claim an exemption from it because this is a part of their religious exercise.
I don't think that's. I don't think that would be. They would necessarily have a claim there because it's not something where the religious organization is being discriminated against along theological lines.
That answer's clear as mud, right? Yeah. So I mean, that's sort of the attorney fighting the hypothetical, right? The hypothetical is, what if they are running a vegetarian restaurant for religious reasons, right? What if their motivation is religious, just like Catholic Charities' motivation is religious? Then can they get the exemption? And I don't think the attorney answered that hypothetical in a satisfactory way.
Yeah.
You all would probably know better than me, but it seemed to me that the argument or the issue they were trying to say is, and it became in the oral argument, they were trying, where do we draw the line on this motivation test? And they kind of, well, it's got to be a religious tradition, and it has to be based on the religion as opposed to a philosophical motive. But it kind of, that would then kind of prioritize or put on a pedestal traditional churches, and any kind of church that's unfamiliar or unaware or not tied directly to society is now going to be rejected. So that, and the whole argument they're making here in the part of their discrimination argument is that, their Catholic Charities is being treated from a more traditional proselytizing Baptist or Protestant church. So their argument itself is creating a kind of discrimination. And that's the problem with, if you get into motivations, you're always going to have to pick and choose what is religion and what isn't. And,
courts are not well equipped to deal with that question, right? It's essentially, if a petitioner claims that their motivations are religious, the court will do a very cursory glance in that direction just to see, like, okay, is it an actual, like, religion? Do you actually believe it? This comes up a lot in prisoner rights cases. Prisoners make a lot of claims and are savvy enough to know that claiming religious motivation helps their claim. And so that's the only context in which courts will look and say, this is not really a sincerely held religious belief. This is something else. And beyond that, courts don't touch it.
Right. But the argument they're making here, in a way, is it seems to be inviting that that's what courts and states are going to have to start doing. And
it's a tricky situation for sure. If the decision comes out going in that direction, it will be an untenable situation for courts.
Yeah, and I think it's really frustrating because it is just so far removed from the reality of the situation. People being thrown off of basically having the benefit of unemployment insurance if their employer suddenly has this exemption because they happen to work at a Catholic hospital as a nurse or something, is really awful. If that happens, that's terrible for actual people who are just trying to work and pay their rent and buy groceries, which is why we stressed that in our brief, and other amicus stressed that as well. And just to remind the audience, this decision, we're at the United States Supreme Court, so this decision isn't just about Wisconsin, it's about the entire country. If they come out and say an employer can just claim a religious motivation and that's good enough, there's nothing about that limits it to the state of Wisconsin. What are your thoughts or reactions, Hirsch, before we move on to another clip from oral arguments?
Sure. So I'm just going to kind of talk about what you just said, Sammy. So you are right about the national implications. And one thing that's unique about a lot of these unemployment cases is that the states do decide them in the first instance. And what the Beckett Fund did is in their cert petition, they did start to detail the state splits as opposed to what you would normally see as a circuit split in cert petitions. So they started to name a few states that actually adopted their rule, and then a few like Wisconsin that said, well, we actually need to look at your activities. So I think everyone is well aware of how far and what states would be affected by this. So if you are wondering if your state would be affected by this and whether your unemployment insurance benefits would be affected, I would just point you to the cert petition for Beckett.
I would actually disagree about that there's any real split in the states. I read their petition and their briefing, and what they were pointing out is just states just not being all that clear in how they're doing it. I mean, they cited, for example, a Massachusetts case that said that they that accepted their argument. Well, the Massachusetts case was an orphanage being run by nuns. So it actually was a church activity. And so that's why it was found to be exempt, was they never got to the second part, the operational test of what's being done here, because this is just really done within the church. So that's why it should be exempt.
They didn't incorporate a separate entity to run an orphanage by secular employees. They didn't do that.
So I think they were kind of creating a split here that didn't really exist.
Yeah, that's interesting. Go ahead.
Sorry, I was just going to say I actually do agree with that, Victor. I only pointed out that their cert petition does have this split. So I do agree that it was a pretty artificial split, and especially I think they cited an Illinois appellate court decision, which was extremely narrow on its facts, and I think might have been similar to the Massachusetts case and the defect there. So at least Beckett thinks there's a split, and the Supreme Court on that ground took the case. Whether it actually has any consequences down the road will be seen, I suppose, after June.
Yeah, exactly. And I think during oral arguments, one justice did get it at least a fair bit and tried to bring things back to how would this rule possibly be workable. And that is Justice Ketanji Brown Jackson, I think, had a good exchange with one of the attorneys arguing for CCB's Catholic Charities position, basically saying if we accept this kind of religious motivation rule versus looking at their actual activities and deciding if they're religious, how would that function and what are you actually asking for? So let's play the clip.
I just have a couple quick points on the statute and your reading. You say that we should read the statute as purpose being religious motivation. And as far as I can tell, purpose doesn't always mean that. So, I mean, purpose can mean many things. It doesn't necessarily mean motive, not necessarily, certainly not unambiguously so. It can mean the ends to be accomplished. It could be fulfilling a particular need. You know, my pen serves a purpose. It allows me to write notes, and that has nothing to do with motivation. And so I guess I'm wondering whether the ambiguity in what the statute means when it says for religious purposes doesn't invite us to consider what Congress was actually trying to do when it was drawing this exemption.
Well, I certainly don't disagree that a purpose includes something, you know, the end to which something is directed. And if you look at the dictionary definitions that we quote on page 15 of our brief, we include a definition of purpose that is like that. And I think it dovetails well with the definitions for operation, which ask what is we are carrying out a principle or an undertaking to an end. And so the end is the purpose, and the end here, according to Catholic Charities Bureau, is to be an effective sign of the charity of Christ.
No, I understand. I understand that that is a version of purpose that is relating to their motivation, which is to be an effective sign of the charity of Christ. But there's another idea of purpose that would be, what is this organization's activities about? What are they offering? And I guess my concern is that view of purpose seems to make more sense of the exemption in this case.
Yeah, that's basically the problem when you extend Catholic Charities' argument from their specific purpose and mission to every religiously affiliated nonprofit out there, right? Like all of the Catholic affiliated hospitals that operate nationally. We were talking about a state split before, but when it comes to states that have religiously affiliated hospitals serving actual people with secular medical problems, that's 50 states. Right, that's happening throughout the nation. And so there's no circuit split there, and every single state will have employees who are not necessarily religious but working at a religious affiliated hospital suddenly losing unemployment insurance benefits.
It's also the college, Notre Dame, Marquette.
That's right.
All those employees would be exempt from unemployment benefits. And the weird thing about this case was, right, the Catholic Charities are reimbursable employers. And so under unemployment law, that means they pay dollar for dollar for the unemployment benefits. So they only have to pay unemployment benefits when one of their employees actually qualifies for unemployment benefits and starts claiming it. And it appears that from the record, they've never had anyone claim unemployment benefits. So there's actually no money at issue in this case. They've never had to pay unemployment benefits. It's been a non-issue. But we're going to decide a case for billions of employees at institutions where they lose work all the time through layoffs and other things, and they will now no longer be eligible for unemployment benefits because if this petitioner's argument is accepted.
That's a really good point. And Victor, there's no one better here to talk about the practical implications than you, because you've experienced employees actually making unemployment claims, right, in Wisconsin.
Yeah.
Can you talk a little bit about what that looks like when they are not covered by the state unemployment insurance program?
Well, typically everyone is covered, except if you're in, independent contractor or you're, employed by a church or a religious school. So they're right now not eligible for unemployment benefits, and so if the COVID-19 pandemic, for example, had a special program that got created to cover people who weren't necessarily eligible for regular unemployment benefits. And so I actually had a lot of Catholic school teachers calling me up to get help because they couldn't get regular unemployment benefits. And there's actually, in the oral arguments and in the briefing, there's mention about a Catholic unemployment program. Well, apparently that wasn't helping people back in 2020 and when they were being laid off during the COVID-19 pandemic because they couldn't get those unemployment benefits. And they didn't know what to do because they were being denied regular unemployment benefits. And I had to explain to them about the whole pandemic unemployment assistance program that was available to them. And that they had to apply this specific program that got created through federal legislation.
So the state exempted religious schools because they're actually, teaching religious doctrine, and so that's a church activity. And then the state created this separate COVID-19 unemployment assistance program, which is bailing out these actual religious organizations.
The federal government did, not the state.
Thank you. Yeah.
And because the Catholic unemployment program did not kick in to help during this time.
Yeah.
Because the Catholic unemployment program is completely discretionary. So
it's not really insurance at all.
No.
Yeah.
Like if you have an auto accident, you're paying an insurance premium to cover you when you get in an accident, not when you get an accident and the insurance company decides whether they want to cover you or not.
Yeah. Man, we could do a whole separate thing. There's an analogous healthcare sharing ministries scheme to be a religious supplement or alternative to health insurance, and that's a disaster. Yeah. It kind of sounds similar in the sense that paying out actual people who need the money is discretionary. But that's an aside. We shouldn't get into that.
Yeah, that could be a whole other episode, which maybe we'll cover coming up here.